Alright, let's dive into today's courtroom chaos. We've truly hit the jackpot this time, because not only are we dealing with a full-blown Karen, but she's also bringing sovereign citizen energy into the mix. And if that combination wasn't bold enough, she decides to fire her attorney right before a probation violation hearing and represent herself. Yes, you heard that correctly. She walks away from professional legal help and steps into the arena solo, convinced she's got it handled. Whenever confidence outweighs competence in a courtroom, things tend to escalate quickly. So buckle up, this one unfolds exactly the way you'd expect.
State versus Ashley Clark, 22 CR 216, Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
I got this myself. Truly the battle cry of every overconfident defendant moments before reality delivers a hard correction. That level of misplaced self-assurance is almost impressive, right up until the consequences kick in. She didn't just dismiss her attorney, she walked away from a negotiated deal that was already sitting on the table, gift-wrapped and ready to go. Instead of accepting a resolution that could have limited the damage, she tossed it aside and chose to step into a probation violation hearing unrepresented. No strategy, no backup plan, just vibes and sovereign citizen talking points. And in a courtroom, that's usually not a winning formula.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir, thank you.
All right, Ms. Clark, any opening statement?
No.
You almost have to admire the confidence, even when it's pointed directly at a brick wall. There's something fascinating about watching someone double down on certainty when the stakes are this high. Unfortunately for her, confidence doesn't cancel out evidence, and it definitely doesn't override procedure. What makes it even more compelling is that this kind of boldness tends to collapse the moment facts enter the room. And speaking of facts, the prosecution doesn't need a dramatic lineup of witnesses here. They're about to call the one person whose testimony alone can unravel this entire defense, her probation officer.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes.
And what was the result of that UA sample from Miss Clark?
It was positive for methamphetamine.
So her
stating that
UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
that's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
What is it with this strategy? I swear, the only practical skill these sovereign citizen experts ever seem to teach is how to fire your lawyer. That's it. Step 1, dismiss competent counsel. Step 2, good luck. Because after that dramatic mic drop, you're completely on your own in a system that actually runs on rules and procedure. There's no proven blueprint for a winning sovereign citizen defense, mainly because it doesn't work. Once they're no longer hiding behind buzzwords and internet scripts, they're forced to engage with real legal standards. And when that moment comes, instead of outmaneuvering the court, they usually end up dismantling their own case piece by piece, just like today's volunteer test subject.
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
Oh, this is where it gets interesting. Because up to this point, the strategy, if we can even call it that, has been to challenge absolutely nothing. No objections, no counter-evidence, no alternative narrative. The state laid out its case, and she essentially nodded along while standing alone at the defense table. So now we arrive at closing arguments, which is typically where a defendant tries to tie everything together and create reasonable doubt. Except here, there's nothing to tie together. No factual disputes raised, no procedural issues successfully argued, just a string of buzzwords floating in the air. To this point, the closing statement isn't about dismantling the prosecution's case. It's more like a live demonstration of how far confidence can carry you when preparation never showed up.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
There's an old saying that fits perfectly here. You're focused on the completely wrong battlefield. Bringing up the IRS in the middle of a probation violation hearing doesn't magically shift jurisdiction or pause reality. The agency pursuing her isn't a tax authority, it's the state of Kansas, and they're addressing very specific violations tied to her sentence. This is what happens when courtroom arguments are built on internet scripts instead of the actual charges in front of you. While she's busy reciting buzzwords about taxable events and surety, the court is focused on missed reports, failed treatment, and positive drug tests. She made her move, dismissed her counsel, and doubled down on this approach. Now all that's left is the outcome, And in situations like this, the prize is rarely the one they imagined.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Whoa, $1,200 a minute. For every single minute in jail? Let's do that math for a second. 60 minutes in an hour, 24 hours in a day. That imaginary invoice is stacking up faster than reality is closing in. The confidence to throw out numbers like that while being taken into custody is almost impressive. Almost. Unfortunately, courtroom consequences don't run on fantasy billing systems. They run on court orders, and those are very real. No matter how creative the math gets, it's not going to cancel out a revoked probation. And just like that, that's where this one wraps up. If there's a takeaway here, it's simple. A public defender with an actual negotiated deal is infinitely more effective than self-representation fueled by internet theories and misplaced confidence. If you enjoyed the breakdown, hit the like button. If you didn't, that's fair too. Drop your thoughts in the comments, subscribe with notifications on so you don't miss the next courtroom saga, and I'll see you in the next one.